laws which were made for Ajmal Kasab are now being applied to Kejriwal.
PMLA, I think, is a ridiculous law. Prevention of Unlawful Activities Act against Terrorism, I think, was a great law.
A divided bar is one of the greatest dangers for democracy. And
a weak media is an even greater danger.
Yeah. Speaking of our time, there has been a lot of growing anxiety, debate, resistance, as well as justifications of the nature of the laws that are changing in India. We've seen very high-profile arrests. We've heard lots of debates around jail and bail. We've seen the redefinition of laws to sometimes move into zones which are problematic, which are, as I said, hotly debated. Prime amongst them is the idea of civil liberties. We have the new PMLA, which was amended in 2022, which has changed the laws and the jurisprudence of the country in some very drastic ways. So at this time of elections, when all our focus is on one pillar of democracy, which is elections, there are two other pillars that preserve what are the principles of our constitution, what is the principles of our public life. Do we care about plurality? Do we care about liberty? Do we care about the just due process of law? That question is really at the heart of the evening today, and what is the state of the media, the courts, and the legal system is what we will be discussing with two very, very eminent people, Sanjay Hegde and Aryama Sundaram, both of them veteran Supreme Court advocates, both of them who've represented many important cases, many of the cases that are in the hot plate of discussion right now. So to unpack this whole range from UCC, 370, PMLA, UAPA, the new codes, right down to the new laws that govern the digital world. We'll be talking to them about all of this. Ladies and gentlemen, please welcome Aryama Sundaram and Sanjay Hegde on stage. I have to say at the outset that I applaud myself for having particular power, which is to bring two Delhi-based, very busy lawyers to Chennai.
On a Sunday evening.
On a Sunday evening, and also bully them into changing their flights into tomorrow morning so that we can really have a full-fledged discussion with them. So thank you very much.
When my first case tomorrow is to get somebody bail under PMLA.
Okay.
Senthil Balaji.
Right. So that, in fact, is the first wonderful plunge pool that I want to get into. You know, as I said, before we even get into the exact laws or cases or this regime versus that regime, I wanted to ask you the principles of what is at stake. Do you believe, both of you individually, that we are moving towards a more illiberal regime of jurisprudence and the courts and the laws in India? Or is it more a function of how a particular government is interpreting laws? Or are we, as I said, using the arm of the law to narrow civil liberties itself? Aryama, you go first.
You know, the question you've asked really covers a whole spectrum. Let me start at the very basis. We have what's called the Constitution of India, and we have what is known as constitutional morality. A state, the court, the various organs of the state do not believe in religious morality, It does not believe in social morality. The only duty is constitutional morality. That is, your duty is to give effect to the Constitution, irrespective of what public opinion is, what views are, and that's why you've seen a whole spate of judgments. Now let's understand one thing. Any law which is framed has to be framed within the four corners of the Constitution. Unfortunately, and I say unfortunately, our Constitution does give a lot of play in the joints. And this is something which we go back to 1950. It gives a lot of play in the joints to make laws which seemingly, abridge your basic rights. And in fact, governments of the day, as is the wont of any government without being political about it, would try to exercise the maximum power they can get to stretch the law to the maximum they can within the Constitution. And this is something you found in the 70s. I needn't say that terrible period we had gone through at a given time. But each time, the courts have tried to bring on the primordial importance of what we call our fundamental rights. Unfortunately, your Constitution has restrictions, and the government of the day uses those restrictions to maximum advantage.
So let me just pin you down on that a little bit to say, and I'm talking a broad framework, we're going to come down into specifics, but broadly, do you feel that we are in a time of more illiberality where the way the courts are interpreting the laws, or the government, the central government is interpreting the laws, or do you think it's in the stream of usualness?
Okay, let's first understand three things. The central government doesn't interpret the law, they make the law. So far as the courts are concerned, their first job is to see whether the law is within the framework of the Constitution. That is one. The interpretation comes in only when there's ambiguity. The interpretation only comes in when they feel that, look, if the law, if taken this way, goes outside the Constitution, but interpreted in another way, comes within. So it is not a question of interpretation of the laws, it is a matter of execution of the laws, which you are today talking about.
So what's your answer on that?
Well, according to me, the laws are being very strictly being executed. There are very difficult laws, some draconian laws. They were draconian because something like terrorism required a draconian law. PMLA, I think, is a ridiculous law. Whereas the Prevention of Unlawful Activities Act against terrorism, I think, was a great law. So you can't have the same yardstick for two different laws.
Okay.
Unfortunately, the Supreme Court, very wrongly, according to me, upheld the PMLA Act. Fortunately, other benches are having second looks at it, and there is a suggestion it may go up for reconsideration.
Okay. I'm going to come back to the PMLA and the UAPA. I just wanted a broad opening sort of assessment, Sanjay, that do you feel that we are, as I said, laws are being sort of acted upon in illiberal ways and also being amended in illiberal ways?
See, let's put it this way. Right from the beginning, we did not value our freedom. Unlike the British, who killed a king to establish a republic, or the French, I frankly think that we got our freedom a bit too easily at a time after the Second World War, when the colonial powers could not hold on. So we wrote a constitution. We may have written a document with magnificent parts in it. But the spirit of constitutionalism never came into the governments, which followed thereafter. Ultimately, it's about law and order. The phrase is law and order. But governments have concentrated more on keeping order. It is the policeman who, within his area and jurisdiction, does not want anything getting out of hand. He says, okay, I'm going to lock up the troublemaker. So, if you have a mob situation, for instance, now what does the policeman do? He locks up the person whom the mob finds to be offensive. So our entire emphasis is not on the rights of the individual, but in maintaining order in society.
So do you think that from 1947 to now, this is an unbroken sort of impulse in the Indian Republic?
It's not been unbroken. We've had our magnificent moments. When we wrote our vision statement, when we wrote our constitution, we said that we shall have liberty, equality, justice for all, assuring the dignity of the individual.
So at this juncture, you know, typically in any of these discussions, there's a kind of whataboutery that kicks in. And I wanted to sort of, you know, stonewall that whataboutery, because every era has had its, you know, very, very dark moments. So if you go back to the emergency, for instance, you know that Indira Gandhi just completely revoked civil liberties. So that's something that you can fight against. You know, it's an extraordinary situation. You know, it's to be denounced and to be fought. Right now, I just want to stick with the, you know, say the last 5 years, because we are in the framework of the elections. That, do you at all feel that there is an extraordinary illiberalism right now, or is it as normative as it's always been?
You've asked about my feelings.
Only your feelings.
Okay, that's a dangerous word. But
it's very dangerous to say that a lawyer has feelings.
Well, you know the one about the lawyer who felt the client's purse and decided that nothing could be done. But be that as it is. The point is that there were, in Indira Gandhi's time, she actually suspended the fundamental rights. There was a declaration of an emergency. The goon squads of Sanjay Gandhi were there, but they were mostly in Delhi and a few places. Now, what has happened is you don't need a declaration. You just don't need a declaration. You've hollowed out the system. Tomorrow, if somebody doesn't like what I say here and turns up at outside my house with a mob and a demonstration, do you think the local policeman is going to come to my help? Or is he going to put me in and say, okay, I put the troublemaker in, now let the courts let him out whenever they do?
So, Sanjay, let me own my mistake. I don't want to go down a completely hypothetical situation. I was asking for your feelings, but feelings restricted to what is happening, not to any hypothetical situation. So let's stop there.
So just 1 minute.
Yeah.
Let me formulate it this way. These harsh laws didn't come in with this government.
Yes.
They came in much earlier. They had the capacity to be abused. What this government has done is to test the very limits of the law. They've pushed it to extremes. And just to conjure, laws which were made for Ajmal Kasab are now being applied to Kejriwal. That's the situation.
Right. So you made a very interesting point, you know, which is that that is why I kept asking both of you whether it's part of a stream of illiberalism within the executive. Because like you rightly said, many of the aspects of the law that are being pushed to the limits right now actually came under the Congress regime. You know, both the PMLA, the FCRA, the UAPA, many of these laws were amended into their draconian aspects during the Congress regime. So let's come to the PMLA, you know. Right now, Aryama, barring the Senthil Balaji case, which you're defending, so you have a particular interest in that. In the framework of it, what is absolutely wrong about the law? You called it a ridiculous law. Why do you say that?
I start by saying we have a constitution. A law has to be tested by the constitution. That is part A. Part B is the application of the law and how it's applied from case to case. You see, unfortunately, when you take a case like Kejriwal's, the fact is he attracted the four corners of the law. Now, it's up to the authorities exercising powers under the law to decide whether or not to arrest him. It is their discretion. They could arrest him. Equally, they could have been lenient and not arrested him. Don't forget, the basis of politics, the basis of political science, is that it is the duty, the function of every political power to try to come to power. Every government will use every single tool which they have to their advantage. The opposition will use the tool of anti-incumbency to their advantage. So what has been done is, first mistake made by the Congress government was to coin the expression or adopt the expression economic terrorism, and said economic terrorism is as bad as violence and different religious terrorism or any other form of terrorism. So they came out with this PMLA Act. The problem now is you have given enough power under that act for for the executive to be able to shape who it proceeds against, how it proceeds, how seriously it proceeds, and how not. There is no manner of doubt that any government in power, if the other parties were in power, they'd have done the same thing. You've seen what has happened in Calcutta, for example. In Calcutta, for example, the kind of laws which are applied so harshly, and that is not the central government in power, it's another government. It is the want of every government to use the law to the hilt for their own advantage. Right. And that is what is being done. The mistake is in taking PMLA as a statute equivalent to a terrorism act and bringing in, those provisions here, which was for terrorism, and suddenly saying economic terrorism and coining this whole issue, which is absolutely ridiculous. And that's what I said.
Right. So, you said about the political, governments misusing this, and I'd like to share a very interesting statistic.
Not misusing it, using it to the hilt.
Using it
There's
to
a bit
the
of a
hilt.
difference.
Yes, but because the framework of our discussion is the courts, I want to come back to that. But I'd like to share a statistic with the audience, which is that from 2005, going by media reports, there have been 5,095 cases under the ED and the PMLA. Only 25 cases have been, have been finished yet, out of which 24 cases have had a conviction. So that's 0.4%, of conviction rate in these cases. And in 2023, just the beginning of 2023, there have been more than 595 cases. According to an Indian Express story, during the Congress regime, it was used against the opposition parties about 50% of the cases. Now, under this regime, it's gone up to about 80% cases, of PMLA against the opposition parties. So that's a kind of statistic. But the fact that only 25 cases have been, sort of brought to a resolution, very stark statistic. So I'd like to come to you. You talked about the governments using it. But what about the courts? Do you have an argument with how the PMLA is framed and the facts that the courts did not test that against the spirit of the Constitution and see whether it was, whether it was upholding the values of the Constitution?
No, the spirit of the Constitution, the living Constitution, constitutional morality are all nice, big words. What happens is that, with due respect to their lordships, sometimes I think they are like those 10 blind men of Hindustan who go out to define an elephant. And the case concerns only the trunk, and then they define the trunk. Somebody says that you hold on to the tail and it looks like a serpent, and you go on that way.
And that's how we lawyers survive.
That's how we lawyers survive. We convince them that it's a trunk.
I think that moment of self-recognition requires a clap.
The Greek word is anagnorisis.
Right.
So the point is that what is the PMLA? I mean, just for the audience's information. How do you launder money? And where did that phrase come from? The phrase came from the prohibition days in the US when Al Capone made a lot of money and he had to account for it. Now, how do you account for it? So he set up his own little people to running laundries, because in a laundry, a person pays cash. And so then there was an entire accounting that this was cash was generated from this business and it went on. So that's how the phrase money laundering came in. You show something as legitimate, derived from legitimate sources, when it is actually the proceeds of crime. Now, there is an international covenant, the Financial Action Task Force, which says that, look, one of the ways of killing off the narco dealers and the arms dealers is to choke their money supply. So if they have proceeds of crime, governments should be able to go after it. And that's how the money laundering acts all around the world came. India said, yes, we'll sign the agreement, we'll sign the treaty, and we'll bring in another act of our own. When we brought about our act, we didn't confine it only to arms and narco deals. We said everything. Corruption, IPC, this, that, and the other. So if your underlying offense was even possibly beating your wife, they'd find some way to say, oh, from that you earned money.
I think that man deserves it.
That man may deserve it, but going after the person's assets, and what is necessary for a conviction under the PMLA? One, you should be held guilty of the basic offense, that which we call the predicate offense, that which is there in the schedule. After you're held guilty, those assets which have in the meanwhile been attached, there you can go after the person and say you laundered that money, so you serve an additional sentence. But you know how things are in
Sanjay,
courts.
I just wanted to bring you back to the question, which is that, yes, I want us to identify today what are the things that we feel are problematic with the law. So you say, one, that it was conjured
It's overbroad. It's overbroad.
So it was conjured to control drug trafficking and, say, terrorism or narcotics. It has now been expanded to include anything.
Yes.
So one is that. Second is, I was asking whether our laws are becoming illiberal. So what are the 3-4 clauses that have made it such a problematic law?
The second is the denial of bail. So if an ED officer decides that he's going to chuck you in, makes it very difficult. The law makes it very difficult for the judge to grant bail, because the requirement is that the judge has to be prima facie satisfied that there was no offense committed and that you're not likely to commit another offense. And all this after listening to the prosecutor. But the judge can't take an overall balanced view of the matter saying, oh, look, this is it, this doesn't seem likely, I'm granting bail. He ends up going into the nitty-gritties of every transaction.
Right. So
Can I just add one thing here? I think for everyone here, it'll be very easy if I say it in one way. Under the law, everyone is innocent till proved guilty. Under the law, you're granted bail as a rule, jail as an exception. What the PMLA Act says is, on the other hand, you are assumed to be guilty until you prove your innocence. You have to be in jail until you prove your innocence. In other words, bail becomes an absolute exception, impossible, which made a lot of sense when you were dealing with terrorist activities. Why? Because you let the terrorist out, he's going to do the offense again and again. Whereas a man who otherwise, on these economic offenses or whatever else, he's not going to be a menace to society. And that's where the error came in.
Right. I'm going to come back to what you just said about the UAPA and terrorism, but just to stick with the PMLA, there's another aspect of it which is very problematic. So one is that you have to almost have the trial before. How do you know whether someone is innocent? You have to have a trial to know that. So a judge has to almost decide whether...
Conduct a mini trial.
Mini trial to even have a bail. Second, the officers don't have to give you the information report of what the case against you is about. They can withhold that, so you don't even really know. The ECIR is not, you don't have to give it immediately. There's a long time span before you have to give that. So all of this, just makes it impossible for people to really prove that whether they've been put in out of vendetta or whether it is out of a sort of true case, So now I wanted to shift to the courts. When this law was created in this way, you said the government wants to control. It's a natural impulse to want to push the limits of control on a citizen. On what grounds would a court accept this complete overturning of the basics of a constitution, which is that, an individual has the right to liberty? So
this law came in 2002.
But it was amended.
That was in the Vajpayee era. Then the courts got into the nitty-gritty. Certain sections were struck down, and those sections were revived by subsequent legislation. When those were challenged, well, sometimes courts are more executive-minded than the executive itself.
Look, let's accept one fact. We can't go away from it. Our whole system of government, the whole system of the state, the pillars between your executive, legislature, and judiciary are meant to uphold, are meant to uphold democracy and your rights, and are always in conflict with each other. They have to be in conflict with each other. Because if the judiciary and the executive agree on everything, then where is your separation of powers? Where's your balance of powers? Where's the watchdog? There is no watchdog. So the very basis of separation of powers is not cooperation between the executive and judiciary. It is a constant tussle between the executive and judiciary. What happens is,
So just
when
one,
a
so
government
just,
is, let me just
on that
finish
point,
this, Shoma.
are you seeing enough tussle right now?
Yes, what I'm seeing is that it has historically happened anytime there is a very strong government with a lot of public support. The courts are alive to the fact that this is a government which so many people support, its policies are supported by so many people, so we should be more reluctant to interfere with their actions. That is the reason you find less interference when there's a strong government, more interference when it's a weaker government, when it's a coalition government. So you find that every time there's an extremely strong government, the courts are alive to the fact that, look, 80% of the people of the country want these policies, want this person, so we should really think twice before we interfere. And that is why you get the feeling that a court is not standing up to the government at that time. It's not that the court is not standing up. It is the court is more circumspect, and it says, look, I must think twice, because obviously the people of India want this. And if it reflects on anybody, I'm sorry to say it reflects on the people of India.
Well, just to explain this slightly further, when Chief Justice Venkatachalaya took oath, the Prime Minister of the day was Narasimha Rao. And he said, I hope we have a cordial relationship between the judiciary and the executive. Chief Justice Venkatachalaya replied, there can't be a cordial relationship. There can only be a correct relationship.
That's, yeah.
There are times when it appears that there is a more than cordial relationship.
Right. So, Sanjay, because if we had, and I did, for the record, reach out to several, officers of the government and, legal officers of the government to come here, but since they've not been able to spare the time and they did want to come, in all fairness, I'd like to put their perspective forward, which is that, even the courts will say that they are really executing the law, even by keeping Kejriwal or any of the others in jail. They're going by the letter of the law. Now, what you just said, that there's a more than cordial relationship between the executive and the judiciary, and that's, of course, disturbing for a democracy. But you recently had a letter by 600 lawyers, many of them your peers, where they said that many critics of the judiciary or the government, including people like yourself, cherry-pick judgments. So when a judgment sits with your particular worldview, you'll be happy. If a particular judgment doesn't sit with your worldview, you'll say there's too much cordiality between, So they said the judiciary is under assault from opposition parties, which is a weird thing to say, but also from lawyers, powerful and eloquent lawyers. What would be your response to that letter?
Well,
that politics has entered law also.
Yeah, that is true. And there was 600 there, maybe there could have been 1,200 on the other side. It's a divided bar is one of the greatest dangers for democracy. And
a weak media is an even greater danger.
Yeah.
Yes. So, what exactly is it that courts do or are required to do? Courts, to my mind, are like the brake in that car out there. Often what the cheerleaders want is not a brake, but they want an accelerator. So, and whether it is the cheerleaders of today or the cheerleaders of the 1970s, In the 1970s, you had, from Chennai itself, you had Mohan Kumar Mangalam calling for a committed judiciary. So now, there's no call for a committed judiciary. Sometimes a little complicity is enough.
Right. Okay, so let me ask you, if within your position as lawyers, would you put yourselves out on a limb today and say which of the cases that are currently, in the eye of public consciousness, which are the ones that you find problematic, which you think are not living by the word and spirit of the Constitution? Which are the cases that give you disquiet?
Well, there are several cases. So,
and I'm not asking you to go into the merits of them.
Okay, one case which does give me disquiet was Article 370 or Ayodhya. Both of these are simply where the courts have worked very hard, and they're much cleverer lawyers than I am, men and women of law. But they've worked very hard to justify what they think the public wants or what the public has voted for. I would have been much more enthusiastic about the courts had there been one single dissent. A dissent is an appeal to the powerful, brooding spirit of the law, to the wisdom of a future day.
Right.
We see these unanimous judgments, which, to my mind, sometimes reeks of groupthink.
But Aryama, this is interesting, he's raised Article 370. You have been a great defender of the removal of Article 370. You're also a defender of the UAPA, which you said just now is a draconian law that was necessary to stop terrorism, So because Sanjay feels that Article 370, there should have at least been a dissenting note. What is your defense of why you think that was well done?
I'm not on the wisdom of the measure.
I told you earlier, Shoma, that the basis of separation of powers is that the executive and the legislature should be at loggerheads. I'm so glad that Sanjay has taken an opposite view so that we can now be in loggerheads and have a separation of views here. Let me start at the very beginning, not in a long way, but a very short way. Why did Article 370 come in the first place? Hari Singh, the Maharaja of Kashmir, was sitting on the fence. Shall I go this way or that way? Pakistan moved towards Kashmir. He then jumped in, and overnight we entered into a pact. Now, without a doubt, the Constitution itself made Article 370 a temporary provision. It made a country within a country. So far as the Constitution, parts of the Constitution of India, which is let me put it this way, it is the Bible, the Bhagavad Gita, the Quran, everything wrapped together for India.
You are quoting the Prime Minister right now.
Was not made, is it? I'm sorry, I didn't hear him. But then obviously on this issue, I think the same as he does. The point is, we made a country within a country. And it was expressly stated that it was a temporary provision. A temporary provision in 1950, pursuant to an agreement reached in 1948. We now keep talking about 75 years after our independence, after the Constitution. Do you call that temporary? How long are we going to encourage a country within a country? How long are we going to allow a status which has been used, maybe not to the liking of the people of Kashmir, but has been used practically as a means of an assault on the sovereignty of India? Maybe the people are not for it, but Article 370 has been practically used in that manner. Now, it's time we turn around and say, look, Kashmir is a part of India or not a part of India? If you're a part of India, then you're as much a part of India as Tamil Nadu is, as any other place is. So why should you be any different? And I think it's time we turned around and said, look here, it's temporary. 75 years from, in my book, is not temporary. It's time we put an end to it. And that's why I think it's about time, thank God, it's been done.
Okay, can I respond there?
Yes.
It was not only about Hari Singh. It was about Sheikh Abdullah. It was about Kashmiriyat. It was about our vision of telling our neighbors that, look, we can have a Muslim majority state in our country which says to you that your two-nation theory was all bad. Now, when we drew up the constitution, we were still a nation emerging. We were a nation which emerged out of partition, out of so many things. We had to carry on. And please, let me remind this audience that it was not until the 1960s that Tamil Nadu decided that it was part of the Indian Union. There were fissures everywhere. We were a nation-building project. The Constitution was part of that. And a solemn constitutional guarantee given in the Constitution. Even if it was temporarily, it had to be abrogated through a constitutional process. The process here was a sleight of hand. You told the Kashmiris that we will not do anything without your consent. And what did you do? You put in your governor there, sent the assembly home, and you had the governor give consent on behalf of the Kashmiris. There are several things that could have been done. And this is not new. I mean, we also made solemn constitutional promises to our princes. We had the privy purses. We took that away also. But that was through a constitutional process. This was constitutional jugglery of a very high order, and I think the Supreme Court winked at it. The other one was Ayodhya, if you want.
I
I don't know how much
answer to
time we
this
have.
in one sentence?
So
I heard the word, Shoma, just one thing. I heard the word constitutional jugglery. I won't say constitutional jugglery. It was a brilliant constitutional maneuver, and there was an opening within the Constitution to do it, and that was taken advantage of and found favor with the Supreme Court. And I think he may not have liked the judgment, but the fact was the Constitution was interpreted to permit it. It was not that it was held, it's against the Constitution, but the court is allowing the government to do it.
See,
Sanjay,
just
just
one
give me
last
one
sentence.
moment.
Just one last sentence. See, in the UK, you had Brexit. The UK Supreme Court said, look, if you have to do it, you have to do it in a particular way. And when the government out there tried jugglery of a similar kind, the court said, no, shut that down. Do it the right way. And they did it the right way.
So I'm going to move away from this, not because I don't want to focus on it, but it's just that an entire session can go on this. But both of you said something which I would like to test with you. You just said that we wanted to show that in a country like India, our conception of nationhood, a Muslim majority state could exist well, be integrated into the nation. So Sanjay, first coming to you, why would you say that that conception is not possible now? Kashmir should remain a Muslim majority state, should be happily integrated into India, get all the respect and civil liberties, most importantly, that any other part of the country gets without a huge army presence over there. Do you not think that's possible? And coming to you then, since you endorse what happened, as I said, I'm not going to give my view on that because that's a whole other session. But attached to 370 is Article 35A, which then allows anybody in the country to come and start buying up land or occupying that place, changing, and there may be a fear, the demographic of that state, which then would dilute the idea that, yes, a Muslim majority state can very happily exist in the Indian Union. So I'd like both of you then to test these views.
Can I go first on this?
Can I just... the problem is, don't see it as a Muslim majority state.
No, you said.
I know. But right now, the problem post-370 abrogation is that as a Jammu and Kashmiri majority state, it's not working. The people of Jammu are against it. The people of Ladakh are against it. And as far as the people of Kashmir are concerned, they just say, okay, let's get on with our lives. But please note that the BJP is not contesting the 3 seats in Kashmir. If it was such a success, they would have definitely gone there. You can't right away 3 seats.
You know, there's a basic, very basic, fundamental fallacy and anomaly in what is being said. On the one hand, you say you would like to integrate a Muslim majority state into the government of India, into India. On the other hand, you say, in order to integrate them, I have to treat them differently. How is that integration? I thought integration is everyone is the same. Integration is not, I integrate you by treating you differently. That's an anomaly. And it doesn't make sense to me.
You know, so I'm going to move away from the specifics of Kashmir. You didn't answer the 35A question. Do you think that at least should be kept out of the
I think so.
book?
I mean, if the fundamental guarantee under the Constitution is that a person can own land, buy land, trade, business, carry on business anywhere in the country, why create? And I agree that places like Himachal Pradesh also do it. But they do it because of geographical reasons, because of protecting tribes there for various reasons. I'm sure if good enough reasons...
It's the same geography between Himachal and Kashmir.
I'm coming to that. Kashmir is today it's a wholly different issue. If tomorrow it can be shown that Kashmir requires as favorable treatment so far as not taking properties, let's say, from tribals, I can understand that. But if it's a question of saying, on the one hand, I have my Article 19 allows me to freedom in the width and length and breadth of India. I can carry on business, trade, anything, length and breadth of India. How can I be restricted from working in a place? How can I be restricted from buying a house in a place? I don't agree with that concept at all, whichever the state is. And I say, if you're going to make an exception, it has to be very, very good reason to make that exception. I'm not justifying the exceptions for Himachal Pradesh also. I've always been against that.
So then, can I just push you further on that to say the Assam issue, where, you know, people are very, the conception of India as a nation was that you can have very diverse, and you'll protect that diversity, you'll protect that plurality. We don't all have to become homogenized into one McDonald's supermarket, you know. So in fact, the Constitution has allowed the 6th schedule for the tribals. Assam was concerned when the language was they felt was under assault. You know, so there was discomfort about immigrants, more on a cultural and language issue than even a religious issue. So there, the governments have been sensitive to that. You want to have an NRC.
That is, you don't want to deprive the tribal of his land and leave him homeless. Therefore, a protection. Now, I'm saying those are exceptional circumstances. Let those exceptional circumstances be made out in Kashmir. Then Kashmir can be given a similar treatment. But dehorse that exceptional circumstance, treating Kashmir as a world apart, that being the reason for not allowing this purchase of land in Article 35A now, I think that is what I'm objecting to. If you say there's a real fear that the tribal over there is going to lose his home, his livelihood and everything, and therefore he should be protected, that's a good reason. Then give that as the reason. Don't just say everybody in the state should be protected.
Okay, like I said, we can have a whole session on this, so, you know, because there's too many facets of it to be discussed. So I'm going to come back to the primary premise of this evening, was to look at whether the legal framework of the country and its execution by the executives as well as the courts is narrowing down our civil liberties. So since we are in this region, let's look at Ladakh. When you had Sonam Wangchuk on protest, the protest could not be more peaceful. What they were really trying to draw attention to cannot be more germane, you know, which is the glaciers receding. It's an environmental issue. It's literally the water bowl of the entire country. What happens there is Section 144 is put. According to them, protesters are taken to the police station, made to sign bonds that they will not protest. And we are seeing this narrowing down of the right to protest across the country. Are you worried about that, Aryama? What about you, Sanjay?
Look, the right to protest, Section 144 being used by the government is something which has always been done. Always. There's always been a fear. There's a temple, a chariot is going, and you're worried people are going to create a problem, you bring in 144. What is 144? Like Sanjay started off by saying, it's to preserve order. More than 5 people can't gather together because there's a chance of creating disorder. Now, 144 has been used by the state time and time again because it's a line of least resistance. Absolutely the least resistance. There can't be a problem. If I prevent people from coming out, then there can't be any violence. So it's been used like that. That is where the courts come in to see whether it's justified or not. We have enough cases where people have gone to court and got the court's order, a direction, to say, permit this procession to go on, permit this protest to go on. And if the courts are approached, they should do so. And if the cases are warranted, they should do so. If they haven't done so, criticize the judgment. Don't throw out the law.
In your view, what was your view on the Ladakh protest?
Well, according to me there, the state obviously brought that out because day one, they didn't know where it was going to head, and they did the same, I'd say rather cowardly way of saying, let me just block everything so nothing happens. I feel if the courts should have interfered, I feel they should have gone to the courts should have interfered, and the court should have allowed the protest to go on, subject to various safeguards to see there was no violence. But like I said earlier, look, the system, the law, what can be done is available. If it's wrongly applied, don't throw out the law, throw out the judge.
The judge or the incompetent fellow, the policeman who says, I can't administer according to the law.
Throw both of them out. Then the judge won't have protection.
Yeah, so very often, and it didn't strike me till a journalist told me that India runs on what is called the Thanedar logic. And I spoke about it earlier. As long as within the Thanedar's jurisdiction, nothing goes wrong, he's a good Thanedar, he'll probably get a promotion, and everything is. And when a politician wants to shut down something, he calls up directly that particular police station or the SSP in charge of it.
Yeah.
This is a reality.
I don't want to get sidetracked.
This is a reality which goes on every day.
Can't we have a better
Sanjay,
system?
just for a moment, I don't want to be pulled into now analyzing the police because they are really executing what either the judiciary or the government says to them. So they're yes, they are
Quite frankly, I think they are the ones who are manipulating both the government as well as the judiciary. No, and I'll tell you why.
Sanjay,
Just 1 second.
Sanjay, I'm sure every poor, and I use the word poor policeman, must be laughing to hear you say that because they're themselves oppressed.
Let me tell you why.
Do they exist? Do they exist anymore, poor policemen?
No.
That's.
Actually,
let me tell you why. And I don't mean the Thanedar alone. I told you that many of the harsh laws were done by the
Congress.
UPA and all that. Each time there is any motion towards liberalizing the law, towards humanizing it, it is the policeman and the Home Secretary will say, look, then we can't control this. This is how your government will start going down. And most governments just say, okay, fine. That is how we'll frame the law so that it is policeman friendly rather than citizen friendly. And that will lead to your next question about the criminal codes.
Yes. We've opened, you both talked about homogenization, which should logically take us to the Uniform Civil Code, but we've left two, untouched tendrils. You spoke of the UAPA. You're going tomorrow morning, Aryaman. You spoke of the UAPA. That actually, see, when it is applied to terrorists, there's no discussion in the media or in the public consciousness. There's no sense of wrongdoing. But let's look at the Bhima Koregaon case. Let's look at Omar Khalid, Let's look at this whole spirit of the anti-national that's come into our country, where people are afraid to speak because you'll be deemed anti-national. And I want to draw the audience's attention to a very interesting case recently, where there was a student at the Tata Institute of Social Sciences that screened a film, the BBC documentary, which the government had banned. So sure enough, it's an administrative, move against him. You can't have a student doing that. But he also invited some controversial professors who spoke about things that were not deemed kosher. He was suspended, but not just suspended, he was suspended for anti-national activities, Now, this is something I would like both of you to comment on. The UAPA is now being invoked against students or against protesters, activists that have been working for 40, 50 years with tribal societies. What do you then think about the law?
I told you that every law can be misused. And to the extent possible, governments of the day would try to misuse it in order to further their own political prospects. You're talking about this. Shall I tell you, we go back to the days of Punjab and the Khalistan. There were three people, the governor, it was governor's rule. I'm not naming them. There was the governor, there was the DGP of police, and there was the Chief Justice. And the governor gave clear instructions saying, round up anybody you suspect, encounters are permitted, arrest. Chief Justice dismissed every single habeas corpus, every single one. And we are talking about the 80s. Now the fact is, at that time, the three of them felt that the situation was so serious that warranted it. Today, somebody thinks something is so serious, it warrants it. Objectively, you and I look at it and say, look, I'm sorry, but how do you make this decision? Though three dignitaries of those days subjectively thought it was very serious. Today, again, they're subjectively thinking, which is why you need a strong court, and this is what I'm saying, is to filter between the subjective and objective thought. And the courts are your last recourse. And I dread to think that they would ever let you down. And if they let you down, I dread to think what will happen to this country. So I'm an eternal optimist, so I do believe that there may be cases where you feel things have gone wrong. But I think by the time, even the present, there are so many issues which have come up, especially the media. The media seems to be the favorite baby of the Supreme Court, because every media person who's arrested is let off by the Supreme Court immediately. So when you look at it that way, I'm sure that you must have great faith in the court.
That's only because you've made an assumption about me being part of the media. But no, I would actually love to have a session at the media and have some big editors here to discuss that. But right now, I don't want to be bifurcated because there's enough ways to be bifurcated. I just want to come then to both of you as lawyers, whether we are discussing the PMLA, whether we are discussing the UAPA, you have made repeatedly a very important point, which is that the courts feel that when there's a strong government, that's the democratic wish of the society, and they are aligned with that,
Not aligned. They are more reluctant to interfere.
More reluctant to take it on. You also talked about subjectivity. So I would like both of you then to address the question that do you think the heart of what's going wrong, if something is going wrong, I feel it is that the definition of things in our laws are not being done with the precision and some of the foresight that, say, the Constitution Assemblies, whatever it is, the Constitution has stood the test of time.
With how many amendments? With how many amendments?
Yes, with amendments. But
but if you have the longest constitution in the world, you will have to have amendments.
No,
and borrowed from so many different
that's what's happening.
Come back to the point that do you think the problem with the UAPA is that what constitutes terrorism or anti-nationalism is not well defined? And, the same comes to the money laundering law, that what constitutes a threat to the nation in terms of economic terrorism is not well defined. So you can use it on anybody in a subjective way.
See, the UAPA came in much before TADA or POTA came in. Okay? The UAPA actually came in after the Dravidian movement here. In the 60s.
You can hear the pin drop silence.
Because most people don't pay attention, right?
Everyone's suddenly feeling they're going to be hauled into jail,
So after that, when did TADA come in? TADA came in once Indira Gandhi got shot in the 80s. And TADA was so misused that the government itself said that we have to withdraw it. Then you had Rajiv Gandhi. Then you brought in back in POTA. And when POTA also got misused, you took it back. So then you fell back on UAPA and started amending it. And so the point is that you've always had harsh laws on the statute book, but the essence of tyranny is the ability to make a harsh law and use it selectively on your enemies.
Yeah.
That is what is happening. And that is what is happening when you start selecting. There's so much discretion. The politician does not directly get his hands dirty or keep a record. As Aryama was telling you about the days of Punjab, we had the governor there. The governor was a very successful chief minister in another place,
Yeah.
where also
And a very
and a
leading
lawyer who also in that other place dealt with the Naxalite problem. So once we get to the stage where we say that the end justifies the means, that's where we go down the slippery slope as far as our liberties are concerned.
I'm sorry, that
Okay.
in justifying the means started in the Bhagavad Gita, if you remember.
Well, now we are getting
Aryama-
into philosophy,
Aryama,
and I can go on this, but
I-
because after all, I am Sanjay.
Right. Okay, there's so many things to discuss. I'm actually going to ask the audience to choose. There's the Uniform Civil Code to discuss, the Gyanvapi Mosque law, case to discuss, and there's the new criminal laws to discuss, and Aryaman wants to catch a flight that he's not going to make it to. So, which of these should we do? Very quickly, 10 more minutes. I want to start with the new criminal laws. The Chief Justice, has called it a watershed moment in the history of the country, where we've decolonized the criminal laws and moved to what both the law minister as well as Mr. Tushar Mehta have spoken of, as that in the past, it was laws which would deliver punishment. Now it is laws that deliver justice. So, Aryama, coming to you, do you feel that this is a good assessment of the changes that have happened with the CRPC? What do you feel optimistic about, and what do you feel are problematic aspects of it?
What changes? It's basically the old wine in a new bottle. There's hardly any change. There are a few tinkerings which have been done. For one thing, that period of remand. The period of remand has been extended, police custody, I think, to 90 days from what it was before, which is not compulsory. It's for the court to decide. Whereas earlier, statutorily, there was a maximum even for the court to permit. Today, that's become looser. I think, by and large, it is more or less the very same law. I do not see a great change in the law today of what was there before, except for saying that, look, we have gone away from Macaulay's regime, we have gone away from the white man's law of 1862 or 1872 or whatever it was, and we've got our new law. But tell me specifically, which provision do you feel has materially changed the criminal jurisprudence, and negatively so?
I'll come to that. I think at least let's put out what's been very positively done, is that it's allowed, remote giving of your witnessing. So that is really a big video
Yes,
conferencing.
but that, you know how dangerous that is. Specifically when you have the policeman just sitting out there, not subjecting himself to cross-examination, your entire case being put through the investigating officer, sitting at a remote location, you don't know who is going to
Sitting
coach
behind
him.
you.
I think we have held our liberties too cheap. And Aryama said, old wine in new bottles. It's like if you took a rare Talisker or something of that kind, and then you said, okay, now we'll replace it with Amrut, but most of it we'll just have some.
I'm glad none of them are
I know,
sponsors.
Amrut is not sponsoring you, is it?
So the thing is that we've not decolonized anything except, yes, a change of labels. But again, it comes back to my old point. Everything that the policemen want has been put in.
Yeah.
So imagine, previously 15 days police remand.
Now
that
90
meant
days.
that the policeman could beat you for 15 days inside.
If the court permitted.
Now 3 months. 3 months, and that too, it can be in installments. He can take you in for a few days.
No, but that was
yes,
already permitted by the Supreme Court.
Yeah, but
this installment,
yes,
even
because-
under the old Act, was permitted by the Supreme Court.
But because the Supreme Court had doubts, the legislature and those behind the legislature have seen to it that everything that they wanted is put in there. It's a policeman's wish list, a Christmas list come true.
Shoma, actually, I'm sorry to tell you this, that anything you find a bit awkward about this new act, is a product of various interpretations given by courts over the years. For example, what we were just talking about, the remand. Yes, remand was only a certain period. But the court said, no, you can put him into judicial custody, but then you can take him out again under police remand. So the fact of the matter is the courts paved the way open for it because it was intrinsically possible. What they've done is they've expressly stated it. Now, when we talk about 90 days, it doesn't mean the man has to be in remand for 90 days. That is to say, the court can permit the remand up to 90 days. Not the police permit the remand, the court. So it's back in the court's hand.
Yeah, well,
but courts don't give you bail ordinarily when you are on police remand.
Yes.
So what happens is that the policeman will say, okay, 10 days, then send him back into JC. After about 15 days, when the court is likely to consider bail, bring him back into police remand. There is so much scope for abuse.
There are a couple of other things which I, thought that would catch your attention at least, is that also now the police can or are meant to do a pre-investigation to see if a prima facie case is made out before they file an FIR. Now that, I think, is a truly, truly difficult, very, very problematic and disturbing
It will
development.
empower the policeman to decide which cases to prosecute, which not to prosecute.
To even file an
And
FIR.
when he's empowered, that means there's so much discretion that, okay, somebody whom he likes, he will not prosecute. And
There is no manner of doubt that the Indian policeman has historically been known to use every situation to his advantage, whether economically or to please his political party, bosses or otherwise. Do you know, years ago, India is the one country where when you make a statement to a police officer, it is not valid evidence. And the reason Macaulay said so and brought that into the code was that he said the Indian policeman is usually uneducated, he is usually irreverent, and invariably corrupt. This was in 1862. I don't think much has changed in 160 years.
there is actually a judgment of the great Justice A.N. Mullah, which says that I know of no armed force which is more corrupt than the UP police.
Well, since there's nobody from the police representing themselves, I feel a little bit bad bashing all of them in this kind of monolithic way, because, there are some attenuating circumstances
all policemen
as well.
are not bad, but unfortunately, like the judiciary, the police also, you see, one bad egg is capable of ruining the entire system. And I say it applies, I'm not saying all policemen, there are some excellent policemen, many of them are. Majority are. But police and judiciary are two places you can't even afford one exception. And if there's one exception, it ruins the whole basket.
Wow. Then we have some very rotten baskets.
We have some very rotten baskets, I'm sorry.
But no, that apart, I just want to draw attention to two more things. One is that the sedition law was said to have been repealed. But what is very problematic about the new criminal code bill is that it actually leaves the definition of anti-nationalism, again, very, very open. So it says that any false or misleading information that threatens the sovereignty, integrity, and unity of the country will then now be deemed anti-national and will evoke the UAPA, etc. So that is very problematic, because then what is misleading information? Who is to decide what is misleading information? If I get an assessment of, say, the economic status of the GDP, for instance, wrong, is that really...
No, I think your operative words are the predicate of what you said, which is the sovereignty, integrity, unity of India. To criticize a government of the day, to criticize government policy, to criticize things like your economic policy, these are not attacking the sovereignty, the integrity, or the unity of India. And this is something the courts have always interpreted in that way, and that interpretation does not change. By the change in the law, the criticism about the sedition law earlier was that it left a lot for the courts to decide. The problem with this is it's again going to leave a lot for the courts to decide. But please remember that the operative words are sovereignty, integrity, and unity. And that should not be a flaw.
Let me tell you the other operative words. Just let me read the section now. Whoever purposely or knowingly by words, either spoken or written, or by signs or by visible representation, or by electronic communication, or by use of financial mean or otherwise, excites or attempts to excite secession or armed rebellion or subversive activities, or encourages feelings of separatist activities, or endangers sovereignty and or unity and integrity of India, or
Basically
indulges
treason.
in. So
Basically
it is
treason.
and each of those words or those catchphrases are extremely subjective. So, by economic means, as a financial journalist, you report something, and suddenly, there are some companies which are nationalist companies within quotes, and some companies which are not nationalist.
No, they're not sponsoring it. But that's a good one to come back to you, Aryman. I was going to say again, I think what's problematic is that if there are any governments that begin to see the government as synonymous with the nation, or any one leader is synonymous with 140 crore Indians, or like any company is seen as a nationalist project, then critiquing any of this becomes a dangerous activity.
But that is where you're making the first mistake. The integrity of India is not the integrity
No,
of the
I am not
of
making the
Congress.
mistake.
No,
People more powerful than us
I'm
are.
saying everybody. The integrity of India is not the integrity of the Congress party or of the BJP. The integrity of India is something different. The sovereignty of India is not the sovereignty of the BJP or the sovereignty of the Congress party. The problem in all this is the way the law is applied. And when applied wrong, that's why you have courts. Now, whether we like it or not, people are going to try to use the laws, misinterpret the laws to the extent they would. That doesn't make the law bad. It makes your execution of the law bad, which is why you have a court. And unfortunately, our system throughout the world is this. The executive misapplies a law, the judiciary comes in and assists in ensuring the justice is done. In countries, you've had presidents who've led attacks, ex-presidents who've led attacks on Capitol Hill. And, it became a thing of, was that an attack on the unity of the country, or was it merely an attack on a building?
Well, I'm just looking at the clock a little bit right now, so either of you can... I don't have a flight. I'm just also looking at the fatigue of the audience. That there's the Uniform Civil Code and the Gyanvapi Mosque case. I'd like to just touch upon both of those because they relate to the law. So let's just take I'm not going into the cultural feelings around either Ayodhya or the Gyanvapi Mosque case, because that's a whole other, and it's a nuanced discussion, I'm just going by the law, that if we had the Places of Worship Act by 1991, and now the courts have allowed the scientific survey of the mosque to open up again, Aryman, what do you see? Do you see that as problematic? Do you think that's fair?
I see it as never ending now. Frankly, it is never ending. You see, there was a reason the act came to be legislated, which was, let bygones be bygones. We have a day.
Cut-off date.
It's a cut-off date. Now, the moment, I've always said, the moment you allow one exception, however harsh your law is, the moment you allow an exception, it gives room for more exceptions. Now, one exception was made, but that exception was in the act itself. The act itself allowed that exception, and I'm talking about Ayodhya.
Yeah.
To now extend it further, I feel we are opening we are opening a Pandora's box, we're really stirring a hornet's nest. And it's never going to end. And I think it has to be stopped. But I must say this, since we're in Chennai right now, I'll say something very, very clearly. You see, the climate in Tamil Nadu, in Chennai, is so much different than in the north. You see, the level of tolerance we have in the south, the level of tolerance, the brotherhood, the fraternity we have here is not in the north. And if this kind of thing was sought to be done in Tamil Nadu, let me tell you, the Hindus would have objected. It wouldn't have been a simple thing of saying one community against another. We are far more, we are more Catholic as people. And I'm sorry to say it, and I am being probably a bit parochial here when I say it, but, well, it's a fact. So when you take it as what you're opening in other parts of the country, you're really opening a Pandora's box.
You see, I spoke about the need to have a dissent and how there was groupthink in Ayodhya. Ayodhya, the judgment, was a carefully constructed judgment where what did the Supreme Court essentially say? The Supreme Court said, look, no mosque, no temple was destroyed to build that mosque. There's a 200-year gap between the previous structure and this structure which was built in 1500. Both sides have proved their case. The Hindus have proved their case, the Muslims have proved their case. Both sides get decrees. But since there has been so much of a fight and this and that, we will use our special powers and give double the land elsewhere so that the Muslims build a mosque and this thing can be put to rest. Essentially, the Supreme Court did a Shiva-like Amrit Manthan and drank up the poison. That's how I see it. But what was the message that the public took? And we are in the era of WhatsApp and hashtags. Oh, it's easy to push off somebody, just give them some land elsewhere, and we have built it on that spot. And once we've built it on that spot, there is this spot, there is that spot, and all these spots are ours. The Supreme Court, and I hold the Supreme Court in very high esteem, but the Supreme Court is not above error. When this case came in, when Gyanvapi came in, the Supreme Court could have very well said, look, there is the act, there is an exception only for Ayodhya, this suit can't continue. There was a very clever argument which said that, oh, I know it has to be, the character has to be preserved as 1940, whatever it was in 1947. But can't a suit be filed which examines what the character was in 1947? That one exception within an exception has led to something which I fear will continue for another 30 years or whatever. And as Aryama said, then we go on. So then we are running into teen nahi, ab 30,000 nahi bachegi koi mazar. But that is the slogan, and that is the reworking of India, which is a different project altogether. And is the Constitution a bulwark or some kind of break against a reimagining of the India that we know? And here, this is what I'd like to tell the audience. The Constitution is a holy book, but it is not something for lawyers like us to quibble. The Constitution is what you, the citizens, make of it. It is your compact between citizen and citizen, that this is how we would like to organize our lives. This is the kind of country that we hope to build. That is the Constitution.
Right. So on that note, I'm going to drop all the other very important matters of state that we were going to discuss, which includes the Uniform Civil Code, which was an interesting and nuanced discussion to have, because there are many perspectives on it. And
I think on Uniform Civil Code, there are only two perspectives. Some say yes, some say no. I, for one, definitely say yes.
I would say no. I would think that much before the civil code, we need a uniform civility code. Right now, we are in an angry country.
That's very well put. For the moment, I'm going to leave it at that, and we can have another session on the UCC. Thank you very much, both of you, for your candid and wise remarks. And thank you, all of you, for being such a patient audience.